Hey class. This is our presentation number 2. We are group 2 and it is Austin Soulsby, Reagan Jackson, and Jesse Neighbors. So let's get started. Our presented situation in question is that Kim is 12 years old and has a claim against her school. Since she is a minor, she sued the school via her mother. Her mother has 5 other children ranging in age from 14 to 19. When Kim has an appointment with her attorney, her mom has no choice but to bring all the other kids too, due to transportation and childcare limitations. If all these people are in the room during the meeting with the attorney, are Kim's statements protected by attorney-client privilege? Our specific research topic is Civil Procedure Rule 26, and our state was either Arkansas or Georgia. This is what we were shown when we looked at class, so we are group 2. Well, we decided that we are going to do Arkansas and Georgia. We knew that in order to choose between the two, we had to research both of them, and we found that they both had interesting information and they both provided with a pretty similar answer. So, as you can see, you will see the research from Arkansas and Georgia in this presentation. I began by going to Westlaw and just looking up the basic attorney-client privilege. I knew that this was the topic of the presentation, and so I was like, let's get a little groundwork for it, and so I looked it up. Basically, I didn't find much of a lead with this, but I did make sure that it said Arkansas and Georgia as my basis of states, and I just looked up the words with no specific search queries or anything like that. I clicked on the first one. It talked about, it was St. Simon's Waterfront v. Hunter McLean, Exley and Dunn. Former client brought action against law firm alleging malpractice with regard to sale of condominiums, breach of fiduciary duty and fraud. Attorney-client privilege applied to communication between law firms' attorneys and its in-house counsel regarding clients' potential claims against the firm as long as there was an actual attorney-client relationship and other requisites of the privilege were met. And once an attorney-client relationship had been established with firm in-house counsel, the materials generated by in-house counsel in connection with those efforts would enjoy work product protection. However, with this case, I found mostly just it talking about using evidence against clients and not necessarily third parties. So that was a little disappointing. But basically, I then went to the next one. It was Jason Holt and Jackson Reconstruction v. McCaslin in her official capacity as prosecuting attorney. So this was a motorist brought action against county prosecutor and accident reconstruction company seeking to intervene and protect his rights, and quash subpoena issued to accident reconstruction company, which prosecutor demanded complete copy of accident reconstruction report made on behalf of motorist. Basically, this had absolutely nothing to do with third parties, so it was definitely another dead end. But then I realized, like, I'm obviously not looking as specific, so I then went straight to Google. I knew that I might need to wrap my head around the idea of attorney-client privilege before looking it up in Westlaw. I typed in attorney-client privilege in Google, and I found this site. NOLO, the attorney-client privilege, most but not necessarily all of what you tell your lawyer's privilege. So, of course, that immediately caught my attention. This says the attorney-client privilege is a rule that preserves the confidentiality of communications between lawyers and clients. Under that rule, attorneys may not divulge their clients' secrets, nor may others force them to. The purpose of the privilege is to encourage clients to openly share information with their lawyers and to let lawyers provide effective representation. The client's privilege. Generally, the attorney-client privilege applies when 1. An actual or potential client communicates with a lawyer regarding legal advice. That matches what Kim did with her client and her mother. The lawyer is acting in a professional capacity rather than, for example, as a friend. This was professional. She was following a lawsuit. The client intended the communications to be private and acted accordingly. That was one of the things that caught my eye. So, was this communication intended to be private? Most likely it was. Kim, she was a minor. She had to have her mother there. But then does that not apply because acting accordingly, does that cover the fact that Kim's mom couldn't find childcare for her other children, had to bring them along? Do we know in entirety if they were in the room or if they maybe signed something or if they were told to keep? We do not know this kind of information, but let's continue. So, lawyers may not reveal oral or written communications with clients that clients reasonably expect to remain private. A lawyer who has received a client's confidences cannot repeat them to anyone outside the legal team without the client's consent. So, that also who is in the legal team in this sense. In that sense, the privilege is the client's, not the lawyer's. The client can decide to forfeit the privilege, but the lawyer cannot. The privilege generally stays in effect after the attorney-client relationship ends and even after the client dies. In other words, the lawyer can never divulge the client's secrets. That just kind of goes on. Well, basically, I noticed that there's a couple cases here, but they weren't specific to Arkansas or Georgia. So then it made me really curious what the attorney-client privilege rules are for those specific states. I then looked up attorney-client privilege rules in Georgia. So, under Georgia law, certain communications between an attorney and a client are deemed confidential and may not be used as evidence in a trial or even seen by the opposing party. I then saw this attorney-client privilege in Georgia, and it looked pretty promising, so I clicked on it. It's basically the courtroom handbook on Georgia evidence, and a couple laws. So there are certain admissions and communications excluded on grounds of public policy. Among those are communications between attorney and client. No party or witness shall be required to make discovery of the advice of his professional advisor consultation with them. This doesn't say much about a third party. So let's scroll down. After looking through these, you kind of see both the client and the attorney have a duty to safeguard the communications from being overheard or intercepted, and insufficient confirmed with confidentiality can destroy the privilege. When an attorney represents two or more clients in the same matter, communications from any client to the attorney are deemed confidential third parties, but not among the clients themselves. Thus, for example, if a partnership is sued by a third party, the party's communications with their attorney would be privileged. If the partners sued one another, however, their communications with the partnership's attorney would not be privileged. Well, as you can see, we do not have a partner suing another partner. It's more of a partner suing a third party, which would be Kim and her mother. So it seems that those will be privileged, but still we're not entirely sure what that means for third party. But what it's looking like is that confidentiality, as you can see here, confidentiality and privilege is destroyed when the client reveals the communication to someone outside the privileged relationship. So we have to think, are the other kids included in this privileged relationship according to the attorney, and is there something specific that was done to make them included or not included? I then moved along to attorney-client privilege rules in Arkansas, and I found this Rule 502, which is actually one of our cited sources. So this says, definition as used in this rule: a client is a person, public officer or corporation, association, or other organization or entity, either public or private, who is rendered professional legal services by a lawyer or who consults a lawyer with a view to obtaining professional legal services from him. A representative of the client is one having authority to obtain professional legal services or to act on advice rendered pursuant thereto on behalf of the client. A lawyer is a person authorized or reasonably believed by the client to be authorized to engage in the practice of law or any state or nation. A representative of the lawyer is one employed by the lawyer to assist the lawyer in the rendition of professional legal services. A communication is confidential if not intended to be disclosed to third persons other than those to whom disclosure is made in furtherance of the rendition of professional legal services to the client and those reasonably necessary for the transmission of the communication. So definitely number 5 is what we wanted to see in this sense, but we had to make sure we read all of it. So as you can see, it says that communication is confidential if not intended to be disclosed to third persons other than those to whom disclosure is made in furtherance. And we would be specifically looking at reasonably necessary for the transmission of the communication. Obviously, Kim's mother had to be there, and obviously she had to bring the kids, and she gave reasons for those. So some can say that all of those people being there is necessary for the transmission of the communication between Kim and the attorney. So I go back here and I see that our topic is Civil Procedure Rule 26. That brings me to Civil Procedure Rule 26, Georgia. Looking that up, I go back to Google again because I feel like I have found that the most interesting I have found that to be okay. I go back to Google because that has given me the most information so far. I looked up Civil Procedure Rule 26 Georgia. Federal Rule of Civil Procedure requires the parties to confer, develop a proposed discovery plan, and submit a report to this court. Honestly, this uh, rule came up kind of a dead end for me, but as you go through this presentation, you see that Austin was able to find some more information on this, and you'll be able to learn a little bit more about this specific rule. I then took my search back to Westlaw, where I put back Arkansas and Georgia in these states and looked up Civil Procedure Rule 26. This now leads you into the next part of our presentation, where you will hear about Georgia from Austin and Arkansas from Reagan, and then I will come back and explain our findings and our written portion with our very anticipated answer to our research question. Thank you.
Hello, class. My group's legal issue has to do with Rule 26 of Civil Procedure in either Arkansas or Georgia. I started my research off with Georgia, and our legal issue is Kim is 12 years old and has a claim against her school. Since she is a minor, she sued the school via her mother. Her mother has 5 other children ranging in ages from 14 to 19. When Kim has an appointment with her attorney, her mom has no choice but to bring all the other kids too, due to transportation and child care limitations. If all these people are in the room during the meeting with the attorney, are Kim's statements protected by attorney-client privilege? Okay, so first I googled Rule 26 of Civil Procedure in Georgia because I couldn't find much on Westlaw. And this rule pretty much dictates the methods of discovery. And on Westlaw, I couldn't find much under statutes and court rules, so I just started with this regular old Google search, and this is what I googled. I was then directed to a uscourts.gov website, which seemed like a pretty legit source. And I clicked on that and skimmed through it. And under section 4, I found the rules regarding privileged, protected, and or confidential information. And subsection B and D states that whether the parties anticipate discovery issues or challenges arising from non-disclosure of allegedly privileged, protected, or confidential information. So this is pretty much the parties must have a conference and decide whether they anticipate any issues regarding privileged communication. And on subsection D, in the conference, it says they have to discuss whether the parties will request a protective order to prevent the further release of information disclosed in discovery. So therefore, it sounds like in Georgia, Kim's attorney could request that any communication conducted in front of her family members, like her siblings and her mom, that information could be deemed inadmissible in court, according to Georgia Rule 26 of Civil Procedure. Hello again, class. So after I researched information on Rule 26 of Civil Procedure, I went on to Westlaw to see if I could find any statutes or cases that seemed relevant to our legal issue scenario. And first I looked up under Georgia jurisdiction, I looked up attorney-client privilege. And I figured I'd start with secondary sources, see if there's any law reports or periodicals or legal encyclopedias that talked about privilege. Under that, I found this: what corporate communications are entitled to attorney-client privilege. I skimmed through this and found communication made in presence of family members. And this brought me to a case in Georgia titled Brown v. State. And this case said that a defendant's mother and sister could be asked to testify against him because they were present during a conversation between the defendant and his attorney. And the court pretty much said that their testimony was not protected by the attorney-client privilege. Right here. And then I went back to advanced search and typed in attorney-client privilege again. And clicked on statutes. And this brought me to a statute titled 24-5-505. Privilege of party or witness. And under relevant notes of decisions, I found this case. Well, first of all, this statute, it states that no party or witness shall be required to testify as to any matter which may incriminate any member of such party or witness's family. And down here under relevant notes and decisions, I found Southern Guardian Insurance Co. of Georgia v. Ash. And this case decided that it was going to apply the statute that doesn't let family members incriminate each other. And then went back and clicked on cases. and I found a case titled Newman v. State. And in this case, the court concluded that in order that for an attorney to properly prepare his or her case, the attorney-client privilege must include the network of agents and employees of both the attorney and the client. And in our scenario, Kim's mother would be legally deemed a necessary agent on behalf of the client of Kim, because since Kim is a minor, and therefore communication in the presence of her mother would be protected by attorney-client privilege. However, the siblings would not be covered by or protected by the attorney-client privilege.
After thorough research of the Civil Procedure Rule 26 and our presented question through the state of Georgia, our answer is as follows. In Georgia, whether a client's statements are protected by the attorney-client privilege when a third party is present can be answered with, it depends. In our scenario, the client is a minor who is filing suit against her school. Therefore, she must sue the school via her mother. Her mother must attend her consultations, and her mother has no choice but to bring all her children with her due to transportation and childcare limitations. So the legal issue is, in Georgia, will the client's statements be protected under the attorney-client privilege with all these people in the room? Rule 26 of the Georgia Rule of Civil Procedure states that during the Rule 26 conference, both parties shall discuss whether either party anticipates any discovery issues or challenges regarding the disclosure of privileged, protected, or confidential information. They must also anticipate whether or not one party may request a protective order to prevent the release of information obtained in discovery. Under these rules, the client's attorney could request that any communication conducted in front of the client's family members may be deemed inadmissible in court. Georgia common law has reaffirmed this rule with decisions such as the one in Newman v. State. In this case, the court held that in order for the attorney to prepare his case, the attorney-client privilege must include the network of agents and employees of both the attorney and the client, acting under the direction of their respective principals to facilitate the legal representation. So our first binding source for Georgia is Newman v. State. In our scenario, the client's mother would be legally deemed a necessary agent on behalf of the client since the client is a minor. However, the children might not be covered. Our next binding source is Southern v. Ash. It's another common law case that can be used as precedent, as the court here utilized Georgia's statute to reject discovery on the basis of state law. This statute states that no party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness or any member of such party or witness's family. However, there is also common law that works against Rule 26 in Georgia law. This case, a criminal law case with no negative treatment, showed that where a burglary defendant's mother and sister testified that they were present at a meeting that the defendant had with his attorney, during which he admitted committing the charged crime. In Brown v. State, the court said that as the witnesses were third parties who overheard the conversation between the defendant and his attorney, their testimony would not be subject to the attorney-client privilege. So, the final answer must be that it depends. It solely depends on the facts, scenario, in court, whether or not communications heard by third parties that are family of the client are protected by the attorney-client privilege. We will now hear from Reagan as he goes over his research of Rule 26 and our proposed question in the state of Arkansas.
Hi everybody, this is Reagan Jackson, and I'm going to be focusing on the Rule 26 of civil procedures. And I have the choice of Arkansas or Georgia, but I've gone with Arkansas, and at this point in the research, I have focused on Arkansas. The question is, Kim is a 12-year-old and has a claim against her school. Since she is a minor, she sued the school via her mother. Her mother has 5 other children ranging in age from 14 to 19. When Kim has an appointment with her attorney, her mom has no choice but to bring all the other kids too. due to transportation and child care limitations. If all these people are in the room during the meeting with the attorney, are Kim's statements protected by attorney-client privilege? Can they make the kids snitch? That's not legal. Anyway, or the way you're supposed to say that. Anyway, okay. All right, so what I did, Rule 26, Arkansas Rules of Civil Procedure in the search bar, and I put my focus just on the state level, on the state of Arkansas. So let's see what happens. So it's on default. It was on default to court cases. I switched it from cases to statute and court rules. Narrowed it down, and here it is, Rule 26. Now this looks good. This looks exactly like what I need. And then I look over here, and I see something else: secondary sources related results, related sources. Inadvertent disclosure. That seems like it's important. Okay, so that's something to remember. It talks about Rule 26, my rule, being referenced in Rule 502 of the Arkansas Rules of Evidence. Okay, that's something to remember, so I'll come back and look at that. So, here we go. I'm going to look at it. First thing I'm going to do is go ahead and click the folder right here. This guy right here, I'm going to put it up in the folder and do that. And then, so it saves the whole document in the folder. And now what I'm going to do is highlight things by relevance. At the time, this seemed like it was relevant because I didn't know much, so I wanted to highlight anything that seemed to make sense. And I forgot to highlight it at this point, but this ended up getting highlighted. The scope of discovery, and it talks about the general rule of it. Parties may obtain discovery regarding any matter not privileged. So if it's not privileged, you need to figure out what is privileged and what is not privileged. And I want to make sure that these kids being here, their information is protected, so they can't be forced to testify. Another thing, as I scroll down, inadvertent disclosure. And that one ends up being what we saw earlier on the right-hand side of the screen. A party who discloses or produces material or information without intending to waive a claim of privilege. So that talks about somebody that gives the information to the other team on accident. They don't want that information out there, but it's like mixed in with other information. So it says, if the party takes the following steps within 14 days, yada, 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 if responses to written discovery are involved, yada, yada. Anyway, steps that have to be taken. If you follow these steps, you can get that information destroyed. They cannot use it against you. But looking down, I see something, and I read it. And in here, I have highlighted blue, something that's very, very helpful. In deciding whether the privilege or protection has been waived, the court shall consider all the material circumstances, including the reasonableness of the precautions taken to prevent inadvertent disclosure. Well, remembering the situation here, says her mom has no choice but to bring all of the other kids too due to transportation and child care limitations. Okay, so that sounds like if she did a reasonable good job of trying to find these things and could not find them, it sounds like it should be protected, but that the details will reveal all. So that's not anything we have to worry about. Protective orders. I highlighted a section and focused on the court in which the action is pending may make an order which justice requires to protect a party or person from annoyance, embarrassment, oppression, undue burden, or expense, including one of the more of the following. First one, that the discovery not be had. I skipped down to number 4, that certain matters not be inquired into, or that the scope of the discovery be limited to certain matters. Skip down again. That a disposition after being sealed be opened only by order of the court. So if I can't get it knocked out altogether, I'll have it limited. And if nothing else, the only way you're going to get your mitts on that information is if the court says that I have to open it up. And hopefully not. I think it's protected, but trying to look at all my avenues. Okay, that's the end of that, so I want to move over to the next, see if there's a 26 point something or other, or if it just goes straight on to 27. So I click the section arrow, and ooh, 26.1 electronic discoveries. Same thing as 26, except it focuses on electronic information. Electronic means relating to technology having electrical, digital, magnetic, wireless, optical, electromagnetic, or similar capabilities. It's electronic and it has information, guys. All right, so I scroll down the page and I see there's things about conference and plans, deciding on what can be shared, what can't be shared. Okay, that's useful. Oh, okay, more stuff. It's useful. All of this stuff I circle, I highlight, and I put it in the folder. This is just a thing I keep on doing if I think it's useful, and I can go back later and delete it if I need to. Okay, claim of privilege or protection after production. Claim of privilege or protection after production of electronic data under these supplemental rules shall be governed by the Rule of Civil Procedure 26b-5 unless application of that rule is modified by agreement of the parties or by order of the court. And that's, again, the inadvertent if passing over the information. I blocked out on the word. Yay me. Okay, that all connects. And so that's a common theme right there, the inadvertent passing information. Okay, moving on. I want to go back and look at the other thing, because inadvertent disclosure. There's a theme. And again, Rule 502, Arkansas Rules of Evidence. So I'm going to punch that in there. Rule 26. Oh, nope, just kidding. Try again. All right. Rule 502, Arkansas Rules of Evidence, statutes and court rules, because I had it on, yeah, so I have it there. 502 shows up. I'm going to click on it. Information here, useful stuff. The client, the representative of the client, of course, the mom, and then the lawyer are all protected. Now, information here. Communication is confidential if not intended to be disclosed to third persons. Okay, lawyer-client privilege. So if it's not intended to be disclosed to third persons, it's considered confidential. So these kids if these kids are not a part of the court case, they're just in there because their mom didn't have anywhere to put them. Technically, that information about them and the information they have is not relevant to the case and should be protected. In the case, the defense can't make them, give the information. Hopefully that works. I'm going to look down. Ooh! In subsection E here, inadvertent disclosure, a disclosure of communication or information covered by the attorney-client privilege or work product doctrine does not operate as a waiver if the disclosing party follows the procedure specified in Rule 26b-5. Here we go again. Of the Rules of Civil Procedure. And in the event of a challenge by a receiving party, the Circuit Court finds in accordance with Rule 26b-5d that there was no waiver. In other words, keep your mitts off of it. Okay, this is very useful because it's all about the question of attorney-client privilege. Okay, so we have pretty much what seems useful, so I want to look for some cases. So I'm going to search third person. So this circles third person. I'm going to point to the back key to search. Now this skips all the extra stuff. At first, I still had it on statute, so I switched it to cases. And a whole bunch of cases showed up that weren't any good. So I went back and searched with end results. I put in third person to put an extra focus on third person, and that resulted in these cases. I went through them, and searching through a basket full of duds, I found a couple of really good cases. Bird v. State, Shankle v. State. Took them, and I placed them in that folder. And of course, like I did with the other stuff, I searched through that document and found relevant stuff. I put the documents in the folder, then I put relevant snippets in there. Searched again, focus on Rule 26 and inadvertent disclosure, and third, and then I went down and added the filter to narrow it down further because there's a lot of cases when I just did that search. So then I added this inadvertent disclosure again to put an extra focus on that, and it narrowed it down to 2, and that's what I came up with. The dead end was Barr v. State, and then Gerber v. Company had a focus on inadvertent disclosure, which is a kind of a common theme. Also, right here, there is this search thing here. So put all this stuff in the folders, do the research snippets, click on this, because sometimes there's useful stuff. This was not the case here. There was nothing useful. So I go into the folder and look at all my results, and it focuses on things like Schenkel v. State talks about it says, yet he made no request or effort to ensure his conversation would be secure from third parties. So you see there's that trend. So effort to keep this information confidential. And we're going to see that through a lot of this research, and I was able to come to my answer based on this. So all that said, I feel pretty good about it, and you'll see my answer.
So, based on the research done on Arkansas, we are left with our final question. Are Kim's statements protected by attorney-client privilege? Basically, so our first binding primary source is the Arkansas Rule of Civil Procedure 26B1. It states the scope of discovery. Unless otherwise limited by order of the court in accordance with these rules, the scope of discovery is as follows. In general, parties may obtain discovery regarding any matter not privileged which is relevant to the issues in the pending actions. The identity and location of persons who have knowledge of any discoverable matter or who will or may be called as a witness at the trial of any cause. It is not ground for objection that the information sought will be inadmissible at the trial if the information sought appears reasonably calculated to lead to the discovery of admissible evidence. Rule 26 of the Arkansas Rule of Civil Procedure states that any non-privileged persons, potentially meaning the siblings, can be forced to talk. If, however, they are privileged, then they cannot be made to talk. Our next binding source is the Rule 502 in the Arkansas Rules of Evidence. It states that the privilege may be claimed by Kim as the client, her mother as the representative of the client, and the attorney under this rule. It states that a communication is confidential if not intended to be disclosed to third persons other than those to whom disclosure is made in furtherance of the rendition of professional legal services to the client or those reasonably necessary for the transmission of the communication. Furthermore, it states a client has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications made for the purpose of facilitating the rendition of professional legal services to the client between himself or his representation and his lawyer. Specifically, Kim's mother stated she had no choice but to bring the 5 other children. Limitations on childcare and transportation were the reasons given. Our next primary binding source is Schenkel v. State. In the case of Schenkel v. State, the appellant argued for 502, but the court ruled against this for the reason that he was well aware of other parties listening to his conversation with his attorney, yet he made no request or effort to ensure his conversation would be secure from third-party listeners. Thus, Officer White's testimony bearing an appellant's telephone conversation is unaffected by the attorney-client privilege. Kim's mother's statement suggests that she did make an effort to secure the conversation from her third-party listeners. In conclusion, for the state of Arkansas and our proposed question, the answer of whether Kim's statements are protected depends solely on whether Kim's mother made the necessary effort to secure the conversation from third-party listeners. So, did she make an effort for her siblings to not hear the conversation, or did she not make an effort and now they have heard the whole supposedly confidential conversation between the attorney and the client?